thanks, Father Matt. Okay, so this is apparently being recorded for the Religious Liberty Initiative at Notre Dame Law School. This is a joint religious liberty and education law forum event, and I'm really delighted to be involved in both of these organizations. I'm the sponsor of the Education Law Forum, and I'm grateful to Maria, who's here, and Father Matt for helping me to. I'm apparently not a good faculty sponsor because it was defunct for a number of years before they helped me reignite this. So this is a great opportunity, and if you're interested, if you're here because you're interested in education, I'll be teaching education law next year. So hope I see you in class. So this case is very important to me. I've been involved in this case, as Father Matt said, well, in a version of this litigation since 1997. As a young attorney, I filed the first challenge to the program at issue in Carson versus Makin. And then since I started my career, I've been involved in a variety of capacities in the school choice movement, and also through the Alliance for Catholic Education. Since being here at Notre Dame, we have some ACE folks in the back, through helping Notre Dame assist Catholic Church and particular Catholic schools who serve disadvantaged children, including especially through parental choice programs. So what I'd like to do is I'd like to talk a little bit about what the Maine school choice litigation is about, what the case is about, what the issue is, a little backstory on the constitutional law, and then a couple of thoughts about the implications of Carson versus Makin, both for the movement for educational choice, parental choice in the United States, as well as more broadly for the cause for religious liberty. Okay, so what is Carson versus Makin about? So Carson versus Makin involves a challenge to Maine's town tuitioning program. So Maine's town tuitioning program is the second oldest school choice program in the nation. That's probably not quite true because there were lots of public funds of private schools in the 19th century when no one was looking. But this program has existed since 1873. Maine is as a rural state, as you know, and unlike many other states, towns in Maine have primary responsibility for educating the children in their town. It's not always feasible in a state like Maine for a town to maintain a high school. And so a town without a high school in Maine, the state law gives it an option, so they can do one of two things. They can contract with a neighboring town to take the kids, and most towns do that. If they choose not to do that, what they can do is they can tuition their high school students, which is to say they can tell the kids in the town, the tuitioning towns, tell the children, the parents of the children, you can take the money that we would have spent on this contract, educate your kids, and you can spend it anywhere in the world. So any private school, any public school, any state, any country. There are children who, in the state of Maine, who have gone to Swiss boarding schools. There are many who go to elite prep schools. Now, if you want to go to an elite prep school or a Swiss boarding school, you only get $9,526. You have to make up the difference, but it's a nice start for your Swiss boarding school. In any event, the kids have the option of attending school anywhere in the United States or in the world. The only restriction is they may not go to a religious school. So why is that? Okay, so this program was launched in 1873, as the website points out. For over 100 years, the children in tuition towns could go to a religious school. But in 1980, the ACLU asked the Attorney General of the state of Maine to issue an opinion on the constitutionality under the Federal Establishment Clause of tuitioning kids to religious schools. The Attorney General issued an opinion letter in 1980 saying that the 107-year-old practice of tuitioning kids to go to Catholic and other private schools in the state of Maine violated the Federal Establishment Clause. And henceforth, kids in tuitioning towns would not be able to go to private schools. At that point, there were a number of Catholic high schools in the state of Maine that had almost exclusively tuitioned kids, and a couple of them closed, which is sad. Anyway, so fast forward, There's a lot of law that changes between 1980 and today. I'm going to talk about the moment that I entered this litigation and then tell you about 3 cases since that time. Okay, so in the moment that I entered this litigation, it was 1997. I was 27 years old, in case you were wondering. It was my first lawsuit. I really wanted to file this lawsuit. The Institute for Justice was a little sketched out about it. They didn't really think it was a good place to start. So in 1997, in 1995 was the first voucher program in the United States that included religious schools. That program was the Milwaukee Parental Choice Program. That was immediately challenged on Establishment Clause grounds. At the same time, Ohio passes what's called the Cleveland Pilot Scholarship Program, a very small voucher program for disadvantaged kids in Cleveland. They could spend the money, I think it was about $2,500, at any school, public or private, in the state of Ohio, but they gave public school districts in the state of Ohio the option of opting in or out of the program. Every single public school district in the state of Ohio opted out, which says something very disturbing about what I believe to be some deep class and race issues. But that's a different story. So the Cleveland Pilot Scholarship Program is in percolating through the state courts. So is the Milwaukee case, which I was involved in. So the optics in Cleveland, by the way, are great. Because of all the public schools opting out, 96% of the kids that were participating in the voucher program in Cleveland were in religious schools. Why is that? Because they were affordable, they were in the city, and they would take the kids. In 1997, when we filed this litigation challenging this was the first challenge to the exclusion of religious schools from school choice programs. Our case, which was called Bagley versus Maine. I have one funny litigation story about it I'll get to in a second. But until most of the litigation leading up to this had been about the inclusion of schools in private school choice programs, right? So, and other benefits extended to kids in religious schools. So it wasn't clear in 1997 if the Establishment Clause prohibited, if Maine was right or not. So Maine had concluded it would be unconstitutional to include religious schools in the voucher program and the tuition program. There was litigation in Cleveland, in Ohio, and Wisconsin that was challenging the inclusion of religious schools in voucher programs. We didn't really know what was going to happen, 50-50. It all came down to Justice O'Connor. We were sure about that. But there had been a series of cases that sort of started building steam for the inclusion of religious schools, the constitutionality of allowing kids to use public funds at their parents' choice to go to a religious school. I don't have to go through them all, but there was one involving a tax deduction in Minnesota. There was a sign language interpretation case where the state of Arizona was sued for allowing a deaf child to use a publicly funded sign language interpreter in a Catholic school. That was upheld. There was a case about a blind minister who was using a public scholarship, and it was in Washington to get a ministry degree, well, not a minister, a ministerial student. That was upheld. So like things seem to be moving in favor of it's not unconstitutional to include religious schools in private school choice programs by 1997. My colleague and I, we really wanted to push the other side. We thought it was a good litigation move to challenge the exclusion of religious schools from these tuitioning programs. Maine has one of them. Vermont has an identical program, and New Hampshire has a nearly identical program. They all exclude religious schools. So we filed this lawsuit, and we lost. On Establishment Clause grounds, the Maine Supreme Court ultimately said that it would violate the Establishment Clause to include religious schools in this tuitioning program. The Attorney General was right. Since then, the programs have been challenged. Maine and Vermont have been challenged a lot, the exclusion, until this spring, completely unsuccessly. This spring, the Second Circuit actually invalidated the exclusion of religious schools from Vermont's tuitioning program. Okay, so what was the basic argument, and why are we right, and why do we win, and what happens between here, then, 1997, and now that means that we should win in this case? Okay, so the first and most important thing, is that in 2002, the Supreme Court upheld the Cleveland Pilot Scholarship Program. It rejected an Establishment Clause challenge to letting kids with vouchers go to religious schools, even though 96% of the students participating in that program were attending religious schools. And the court basically said that what the Establishment Clause requires is neutrality toward religion, right? So if the government wants to send kids to private schools, it can do so on a religion-neutral basis. It basically says to poor parents in the city of Cleveland, here's some money, go find a school. It can be a religious school, but that's religion neutral, and moreover, the decision maker about where the money goes is the parent, right? Not the government. So the Maine Supreme Court had rejected our challenge to including our argument that it violated the Free Exercise Clause to exclude religious schools. We said it violated the Free Exercise Clause to exclude religious schools from the town tuitioning program. Maine Supreme Court said it actually was required by the Establishment Clause. 2002, that argument's off the table. It's clearly not unconstitutional to include religious schools in voucher programs like Maine's town tuitioning program. Maine says, we don't care, we're going to keep doing it anyway. We like the separation of church and state. We think the court's wrong, whatever. We're just not going to change our policy. Same goes for Vermont, and same goes for New Hampshire. So after Zellman, which is 2002, the argument that it is required to exclude religious schools is off the table. And the only thing left, the only legal argument left is, well, if you don't have to do it, can you just do it for kicks? Right? So can you just choose to exclude religious schools because you want more separation between the state and church? I don't like separation of church and state. It's not in the Constitution. Never use those words in the sentence. Can you just choose because you are Maine to not fund religious education? Even though you could, Maine's argument is we could, we just don't have to. So then there's a number of free exercise challenges to the Maine's program, to Vermont's program, basically percolating up and down in the federal and state courts. There's actually been a lot of challenges, historically unsuccessful, until this spring, the Second Circuit invalidated on free exercise grounds Vermont's exclusion of religious schools from its tuitioning program. So what happened between Zellman and the Second Circuit opinion? So there's two really important cases. I hate to get in the weeds, but I'm going to do it anyway. The two really important cases. One is a case called Trinity Lutheran Church versus Comer. So you might think this is a joke, but it's not. So Missouri established a program for playground resurfacing for preschools. It was a playground resurfacing program that gave preschools recycled tires to resurface their playgrounds. The Trinity Lutheran Church in Columbia, Missouri, ran a preschool, as many Lutheran churches do, and it applied. The state of Missouri said, you are like the perfect applicant. We love you in every possible way, but unfortunately we can't give you any recycled tires for your playground because our state constitution prohibits us from doing so because we're not allowed to give recycled tires to religious preschools. I'm going to get to the state constitutional thing in a minute. But, so that case, Missouri says, kind of reluctantly, I don't really think they believed it, but they're like, we wish we could give you the tires, but just golly jeepers, our constitution requires us to discriminate against you for being religious. So this goes up to the Supreme Court, and the court says that Missouri's action violated the Free Exercise Clause, because it wasn't neutral toward religion. Remember what I said about Zellman, that voucher programs, it's okay to include the schools as long as they're religion neutral. But what happens in Trinity Lutheran is the court says that's a two-way street. Religion neutrality runs both ways. If you want to have a general benefit program, if you exclude religious providers just because they're religious, that's actually not religion neutral. So that violates the Free Exercise Clause. There's a weird footnote. I'm not even going to get started. The Chief Justice, probably trying to get to 7-2 instead of 5-4, drops a footnote and says, this is just about tires. We're not saying whether it's about something else, like not tires or money. And also, this is clearly discriminating against this preschool because of its religious character, its status. It's just a playground. We're not saying that the state of Missouri or any other state might not be able to discriminate against a religious provider in order to prevent money being spent on religious uses. I'm going to get to that in a second. Okay, so there's a couple questions remaining, including whether Trinity Lutheran was just about tires. And then last year, a very, very important case called Espinoza versus Montana was decided. So Espinoza versus Montana, Montana passed a little bitty scholarship program. It provided a $150 tax credit for benefits for donations to private organizations that provide school choice for Montana residents. And this program was challenged, and the Montana Supreme Court said, it's unconstitutional under Montana's constitution. It's clearly constitutional under the federal constitution to give a tax benefit of $150 for donations to private scholarship programs, but not under Montana's constitution. We cannot allow this to go forward because religious schools are included in the program. So they invalidate the whole program. This goes up to Supreme Court. Supreme Court says 5-4, Espinoza versus Montana. That the Montana Supreme Court's decision invalidating this tax credit scholarship program violated the free exercise clause because it was motivated by religious discrimination. The day Espinoza was decided, this is a theme with my 9-year-old who thinks his mom was a weirdo, I was picking up my son at swim team, which he hates, and I was sobbing. Like, this is my whole life. I can't believe it's happened. Finally, I won. And she's like, what's the matter with you, Mommy? I'm like, it's a good thing. It's fine. So anyway, so Montana, this is a huge victory. Just to really kind of put in perspective for those of you who are Catholic, but that the Catholic Church has been making the argument vindicated in Espinoza versus Montana for 175 plus years. The basic argument is that if you're going to extend educational benefits, you cannot exclude providers because they're religious. That was what Espinoza versus Montana said. That argument was made in the mid-1850s by Catholic bishops and has been made consistently. That's a huge deal. Okay, so we have, you can include religious providers, probably have to include religious providers. Espinoza is decided during the time that Espinoza is pending. The First Circuit is holding, pending Espinoza. He's smart, they're smart, really smart panel, included Justice Souter sitting by designation. So he knew how to act. He sat there, said, we're going to sit on this one and wait to see what happens. And then I'm cynical. And then Justice Souter said, and then we'll find a way, no matter what happens, to say that it's okay to continue excluding religious schools from Maine's tuition program, which is exactly what the Supreme Court did. So the First Circuit did. After Espinoza, about a month and a half later, First Circuit comes down and says, perfectly constitutional to exclude religious schools from Maine's tuition program because, you know, really what was at issue here wasn't status-based discrimination. They weren't being excluded for being religious schools. It was use-based. They were being excluded for doing religious things. That's okay. That's what Trinity Lutheran said. Remember, like, it might be about tires and other stuff. This is more like, they'd be happy to send money to religious schools that were like religiously affiliated. That'd be okay. In fact, there is some evidence that they are, but they just don't want to spend money on religious education, and the Supreme Court, according to the First Circuit, said that's okay. Okay, so that's what is at issue in Carson. So in two different amicus briefs that I was involved in with some of our awesome students. First, at the cert stage, asking the court to review Carson versus Makin, and then most recently in a brief at the merit stage on behalf of the petitioners in Carson versus Makin, we really urged the court and the Religious Liberty Initiative to take the case and make clear that there is no distinction between religious status and religious use. And I want to talk And that's exactly what happened. So Carson is granted, and I was picking up my son from swim team, and 1 year later, and I was crying. He was like, "Mommy," I'm like, "It's good, I promise." Fine, it's a happy cry. He's like, "My mom is a weirdo." Anyway, so Carson has been granted, and the only question in Carson is there a distinction between discrimination based upon the status of religious organization, which is not permissible, and discrimination based upon, in order to prevent the expenditure of public funds on religious uses, which the First Circuit said was permissible, and moreover said that's what was going on in Maine. So I want to just say a couple of things about why I think this distinction falls apart, and why the court, I actually think they took the case for two reasons. One, the Second Circuit created a split, and the other is I don't think they believe, I think they just took it to clean up the mess that they created, but I'm an optimist. So this distinction between status versus use, in my view, falls apart and is quite pernicious quite quickly. And I want to talk about why that is using the brief that we filed. But just to begin, I actually want to read from Justice Gorsuch's concurrence in Trinity Lutheran. He says that this distinction falls apart too quickly. Because to be a religious organization or a school, and particularly school, is to do religious things. It's not like if you're a Trinity Lutheran was being a religious preschool. Like it was doing, I bet they like said grace before meals and stuff. And if anybody scraped their knee, they might have said Jesus loves you while they're putting the Band-Aid on or something. But so Justice Gorsuch says in Trinity Lutheran, and complaining about this maybe, and one thing I should say about the status use distinction is the Chief Justice in Trinity, in Espinoza says, well, it actually probably doesn't mean anything, but we don't need to decide right now. So now we're back to decide. Okay, so Justice Gorsuch, does a religious man say grace before dinner, or does a man begin his meal in a religious manner? Is it a religious group that built the playground, or did a group build the playground so that it might be used to advance a religious mission? The distinction blurs in much the same way the line between acts and omission blurred when stared too long. And that's actually the argument that we made in this brief twice. So we represented the Partnership for Inner City Education, which operates 9 Catholic schools for desperately poor children in New York and Cleveland. The Council for Islamic Schools in North America, which is an accreditation organization for Islamic schools in North America. I can try to figure that out. So there are about 9,000 kids in the schools that were operated by the partnership schools, including our ACE friends. ACE teachers teach in the partnership schools. The sister schools have about 30,000 children. At the search stage, we represented the Orthodox Union, which is the largest Orthodox Jewish synagogue organization in the country. And we have a different Jewish client the second time around because the Orthodox Union chose to go out on its own, which is fine. But altogether, we had about 250,000 kids represented in our brief. And what argument we tried to make to the court was, in all 3 of these faith traditions and others, there isn't a distinction between being religious and doing religion, right? So by the partnership schools, which is an amazing organization in my view, says that in order to thrive, Catholic schools need to be both, quote, academic excellence and joyous, productive, faith-filled school cultures. The superintendent, who's a friend of mine, Kathleen Porter McGee, says that in order to succeed, Catholic schools must be Catholic on the inside. That integrate the objectivity of truth, the belief that every human person is made in God's image, the importance of forming virtuous habits, and happiness that comes from using one's free will to choose the good. Pope John Paul says, the special character of the Catholic school, the underlying reason for it, is precisely the quality of the religious instruction integrated into the education of the pupils. What is the difference between being a Catholic school and doing Catholic things? Likewise, the very essence of Islamic schools is the teaching of Islam. So to receive accreditation from the Council of Islamic Schools in North America, the schools must incorporate Islamic values that are aligned with the school's mission and vision in all subjects and foster a positive identity, Islamic identity among students. And in Jewish day schools, which interestingly, they're a little harder case because does anybody go to a Jewish day school? Anyway, Jewish day schools have a dual curriculum, so they actually do separate religious instruction from Judaic instruction. However, let's see my good quotes here. Students are taught to synthesize Judaic and secular knowledge, for the schools believe, quote, Torah, faith, religious learning on one side, and science, worldly knowledge on the other, together offers a more overarching and truer vision than either set alone. So what our brief says on behalf of these, and we actually have some other examples too, is basically the status use distinction in pro-choice programs fall apart. You can't say, it's not we're discriminating against the schools for being religious, we're just discriminating against them for being religious. Because in order to be an Islamic school or a Jewish school or a Catholic school, you have to live an integrated life. That's what it is. Not that it's carried out perfectly in all of these settings, but certainly that's the ideal. The integration of, in our faith tradition, of faith and reason is central to what we try to do. Okay, so that's our brief. Supreme Court will decide. We'll hear arguments in this case in a less than a month, and I think in December 9th, you can listen. Before I would, and people have probably have lots of questions, I want to talk about what's at stake. I'm going to start at a very high level and then talk about what's at stake in education policy, and then talk a little more broadly about what's at stake more broadly for religious liberty. So if the Supreme Court were to say, if you get 5 votes for there's the status use distinction, one thing that Justice Gorsuch says in Trinity Lutheran, that the Chief says in Trinity Lutheran, he's like, what? The state of Missouri, when the state of Missouri says to Trinity Lutheran preschool, you can't participate in the tire resurfacing program for your preschool playground because you're religious, what it's doing is putting Trinity Lutheran preschool to an unconstitutional choice. Participate or stay religious. That's your choice. So the status use distinction that the court has, unfortunately, I think, created unnecessary confusion about. To me, I think the important thing is a high level to keep in mind that if the court were to endorse the distinction between religious status and religious use, it would be easy with a sleight of hand to just authorize government providers of funds and benefits everywhere to do the same thing. Like, you can't, Muslim school, participate in our voucher program because you're religious. It's the same thing. You're saying you could either participate or stay Muslim. They wouldn't. Muslim schools wouldn't say like they could be Muslim without teaching the Quran or integrating the teaching of the Quran with secular subjects. Catholic schools wouldn't say that, especially the K sector, but even in the high school sector, in my experience as a Catholic school mom, the entire second grade curriculum at St. Joseph Grade School is centered around preparation for First Communion. Like, math is separate, like everything, which I like. They learn stuff. It's not like it's just Jesus, but it's really integrated. So to say you can participate in the Indiana School Choice Program, or you can stay religious. That is what is at stake. So, and that is for religious providers of all kinds of services, not just schools. Okay, so that's one thing that's at stake. Okay, and then I'm going to talk about maybe 2.5 education things that are, I think, at stake. There are 31 states in the United States that have private school choice in the United States now. This has been the most successful year in the history of the private school choice movement. If you leave aside tuitioning, which are obviously very old programs, the first modern voucher program was enacted in 1990. So to think about the number of programs that have been enacted between 1990 and now, there are, it depends on how you count, there are close to 70 school choice programs in the country. And in 31 states. This year, 21 programs were enacted, improved, or expanded. 3 new states were added to the school choice roster: West Virginia, Kentucky, and Missouri. And so, in part, by the way, this is very COVID-driven. because Catholic and other private schools opened when public schools stayed closed, and parents were annoyed. And they're like, why could they do it? And why are we still remote? And so this is one of the reasons there's been so much success, I think. Now, one of the major impediments to the further expansion of private school choice in the United States is so-called Blaine amendments, or those state establishment clauses. So Blaine amendments are called Blaine amendments because this guy was Speaker of House and later a United States Senator from Maine, he really wanted to get elected to be president on a platform of anti-Catholicism. And so he attempted to amend the United States Constitution in the 1870s to prohibit the funding of sectarian schools. This failed by 3 votes, but thereafter, states were required to enact and put a Blaine Amendment in their own constitutions as a requirement for entering the Union. 38 states have some provision that counts-ish as a Blaine Amendment. Basically, provisions often that speak directly to education and that purport to limit more restrictively than the federal establishment clause state expenditures on private religious education. To really get a picture of the history, it's fun if you read Espinoza versus Montana, like Justice Alito has a whole thing on the anti-Catholic history of Blaine amendments. But I have a couple of cartoons. These are in my office. So this is one cartoon. Thomas Nast really didn't like the Catholic Church. You'll see this is a priest. There's some people from the Vatican off in a boat here. He's got handcuffs. So he's got handcuffs that you can see he's priestly slavery. And he's beckoning these good people who were freed slaves, protected by the Holy Bible and the Emancipation Proclamation, and just trying desperately to get their children to the public school. He's beckoning them into priestly slavery via Catholic schools. That is the history of the Blaine Amendments. And this one is even, that's the wrong one. Let's see if I can go back. This one is the more famous one. So this is another Thomas Nast cartoon. So these crocodiles are crawling to devour this man protecting this sweet public school children, again with the Holy Bible. And the crocodiles, you will see, are bishops. Now the bishops are going to eat the public school teacher, but this poor lady up here, it's already too late for her. She's getting dragged off to the gallows for being a very valiant public school teacher. And in the back, it's Tammany Hall and the political Roman Catholic school. And there are some of these sayings are racist and anti-Catholic. There's a litigation going on in the Blaine Amendment in South Carolina. It's quite evident, quite historically clear that the Blaine Amendment, which prohibited the funding of religious education, went hand in hand with the disenfranchisement of freed slaves, because the freed slaves were being disenfranchised or being illiterate, and missionaries were coming down from the north to educate them, which was foiling the segregationist disenfranchisement plans. So it's an ugly history. So these states, some state courts have said, well, even if this federal establishment clause doesn't require, doesn't prohibit money from going to religious schools, our Blaine Amendment does. Espinoza basically takes that argument off the table, but if we reinsert the status use distinction, it's right back on the table. So it will send a victory in Carson versus Makin sends a pretty clear message to the state courts that the Blaine Amendments cannot be used as an excuse for discrimination, as they were in Missouri and in Montana. Interestingly, Maine does not have an establishment clause. It's not actually arguing that it's required to do this; it just sort of wants to. Okay, so that's one. So if we want maybe some of you don't, but the continued expansion of private choice in the United States is very much contingent on defanging the Blaine Amendments and not allowing the state courts to use them as a vehicle for blocking innovation, democratic innovations that expand opportunities for kids, particularly disadvantaged kids. And final thing about this is it's not just about anti-Catholicism. keep in mind that for most disadvantaged kids, voucher programs tend to have pretty low scholarship funds. Scholarship amounts, they tap out about $8,000, and in many states it's lower than that. So it's faith-based schools that provide an affordable, high-quality education for these kids. Catholic schools historically, Lutheran schools in urban areas, and they're also the schools that are present in the neighborhoods where the kids are. I would like to have bigger scholarship amounts so more people would enter the private school choice market, but so far that hasn't happened. Okay, so that's sort of implication number one. The second implication is charter schools. Now, this is a little, I have to say, this is my little hobby horse, and most people think I'm nuts, but if you look at that, this is a map that shows private school choice. It's a little dated because a couple of states haven't been added yet, but oh, actually they updated it. Anyway, the dark blue states have school choice, private school choice, and charter schools. So charter schools are not supposed to move because of the video. Charter schools are privately operated schools, but they're designated public schools in all states. There are 43 states with charter schools. So more states with charter schools than the private school choice. And the money tends to be better. It's usually about 2/3 more than a voucher or a scholarship tax credit. Every single charter school law requires charter schools to be secular. And there's a couple reasons that is. One is because every single charter school law says they're public schools. Now, I actually don't think that matters. The Fourth Circuit just held that charter schools are not public schools, which is big. And so is the Ninth Circuit, interestingly. They've said, I don't care what the state of California and the state of South Carolina say, they're privately operated schools, they're private schools, they're not bound by the Constitution. Interestingly, the charter school people hate that. They're fighting tooth and nail to get that opinion overturned in the Fourth Circuit. But if they're not public schools, and that's another whole talk, happy to ask questions. If they're not private schools, then I don't think the state can, if they're not public schools, they're not state actors, if they're not government schools must be secular. If they're not government schools, I don't think the state can tell them they have to be secular. So Carson versus Makin has the second sort of wave implications in charter schools. Third wave implications, though, is there are hundreds of programs in the United States, charitable choice programs, social services programs that says to Catholic charities, United Methodist services, whatever, you can have some government money, but you can't spend it on religious stuff. You have to segregate the money. If Carson versus Makin comes down with saying there's no distinction between status and use, then those programs come into, the constitutionality of those programs come into question. The New York cities, these are both education examples. I'm sure I could find a lot of job training, homelessness, and other examples. But New York City's universal pre-K program says you can be a religious provider, but you can't run a religious preschool. So you have these bizarre situations where there are Catholic schools, Jewish schools that are Catholic and Jewish, except for the basement, where the kids are in non-Catholic preschools. Some of you may have taught in one of these schools. It's the hardship they have one of these schools. So when it's like Jesus is everywhere but the basement. And so that, I think, definitely it calls into question if the status use distinction goes away. That program is maybe suspect already. The infrastructure law, my husband just told me this yesterday, universal childcare cannot be a religious provider, current law, under the current draft. That actually is unconstitutional under Espinoza and Trinity Lutheran, because that's just status-based. You can't be a religiously affiliated provider. That's actually already unconstitutional, and they know it. It's this is one thing that drives me nuts about politics. Sometimes I think people just eventually they'll invalidate it, but it looks good. So those are all really big implications for Carson versus Makin. So that's all I have to say about the case. And I'm happy to take any questions you may have about school choice, religious liberty, anything else. Yes?
On the status use distinction, I mean, just because the distinction itself falls apart doesn't mean you can't somehow, come to a conclusion in between, right? I mean, I can imagine case-by-case factual analysis, or perhaps something where they say, if the status wasn't there, then it would still be used the same. Otherwise, everything else is religious use. Why does it have to be like a sort of, it swings entirely one way or the other?
So I guess you could say in my charitable choice examples, right? Like if you can segregate your funds, you must. If you can't segregate your funds, you just can't participate. That would be the only way that I can imagine. So the schools that we represented, the Jewish schools, the Muslim schools, the Catholic schools, they couldn't participate and remain who they are as religious schools, right? So it is in fact the case, I suppose, and because in part, by the way, in part driven by the fact that this is the way that charities have been funded for many, many years. There are lots of religiously affiliated charitable providers who provide secular services who might choose to do otherwise, right? If they could. So you could say my third wave of implication that all restrictions on spending government, that neutrality requires that people to fully live out their faith commitments. That's the biggest stretch in my argument, I think. But I think it falls apart pretty fast. I mean, how do you say to the Muslim school, you can only participate if you can be Muslim, but you can't, I mean, to my clients, they would say that that's like saying to them, you could be Muslim, but you can't be Muslim. I mean, I think you're saying you can be Muslim, but you can't do Muslim stuff. Like, so you can be motivated, and many, many people of good faith are motivated by faith to do really good secular things, right? So you could say you could be a soup kitchen, but you can't be a Christian soup kitchen. But for our clients, the distinction between being Catholic and teaching Catholicism it doesn't exist, because they would feel that if they were to stop teaching Catholicism, they would cease to be Catholic. So I think that it's hard, especially in the education context, right? Now, I think in the Jewish day school context, and I'm certainly no expert, I have a good friend, Michael Helfand, who teaches at Pepperdine, is Orthodox. He's the one who stole the Orthodox Union as our client, but I've forgiven him. He was like, I'm like, Michael, the Orthodox Union is bailing on us. He goes, oh, I know, they told him to. He might say in many Jewish day schools they're comfortable with segregation enough that you could pull it off. But in Orthodox day schools, it's much less common. It'd be very, very hard for them to do so. Yeah.
If Carson goes your way, could you see a future in which, like, so the voucher programs now are based on the fact that the towns don't have schools? Could you see somewhere along the line someone saying, well, my town has a public school, but I want to send my kid to religious school, so give me the money because you're giving it to these people and I'm being discriminated against just because I happen to live in this town?
Yeah, so in Espinoza, the opinion says the state is under no obligation to fund private education, but if it does fund private education, it cannot choose to exclude religious private providers. You can't. And by the way, there's so much. This area of law is really messy. There have been arguments in the past unsuccessfully made, basically what you just said. It's like a violation of my free exercise rights, not for the government to send my kid to religious schools. Those have been unsuccessful. So I don't see that happening. Now, in the charter school context, and Justice Breyer, by the way, in his dissent in Espinoza says, wait a second, what about charter schools? They're privately operated. Which line do they fall on? By operating a charter school program, has the state of, where's a charter school program? So like Texas, lots of charter schools, no private school choice. By setting up charter schools, has the state of Texas funded private education? But in a place like where there's neither, Nebraska, they have neither charter schools nor private school choice in South Dakota. I don't think that's a winning argument. That intersects with other areas of First Amendment law, like the question about the scope of the free exercise rights to get an exemption. But even if, say, even if the Employment Division versus Smith is overturned, I don't think that means the government sort of is obligated to subsidize your religious practice. It's just here, it's really the scope of the anti-discrimination principle. Peter?
Have there been challenges to these sorts of laws from I guess what you might call a nominally religious school that ended up getting denied funding?
So there were a couple early on in the Wisconsin case. So the first 5 years of the Wisconsin voucher program only included secular. It was pre-charter schools. So charter schools didn't exist in the United States until 1991, 1 year after the voucher program comes online. So there were charter schools in Milwaukee, and there were a bunch of these, mostly honestly like Afrocentric private, really small private schools that were getting funded because the original part of the voucher program, 5 years, did not include religious schools. And there was a predominantly Black Catholic high school. The principal or whoever, his name was Brother Bob, he decided that he was going to apply and say the restriction was you couldn't go to a pervasively sectarian school. And he said, it might be called Mesmer High School. Anyway, he said, we're not Catholic. We're like sort of Catholic, but not really Catholic. So we're not pervasively sectarian. That was rejected. Also, the litigants were furious about that guy. But in any event, also there is a story that I heard when I was litigating the Maine case years ago, that Maine had rejected the tuitioning of a student who was attending the National Cathedral School in D.C. because it was religious, and they were able to get a letter from the National Cathedral School certifying that they were not, in fact, religious. So theoretically, all those prep schools, the Andover, Exeter, Yale, Harvard, they're all religious originally. Yeah,
in general, are private religious schools subjected to the same requirements as public schools when it comes to access to students with disabilities or English learners, etc.?
So private schools generally are very lightly regulated. Private schools participating in private school choice programs are a little more regulated. They typically do not have, for your disability point, they typically do not have to take the same range of kids because they're not entitled to the same services. So like the IDEA funding doesn't extend to those schools. Now, charter schools are an interesting example because charter schools technically are required to take all the same kids, but the school district and or state is allowed to make alternative arrangements for the kids. Even public schools, there's a range of disabilities that public schools can't handle, and they do make alternative arrangements. But in a charter school world, there is a big debate about kids with mild to moderate learning disabilities, whether they're getting excluded and or not. They're not that. There are fewer of them in charter schools, but there's kind of this fight. This is something that's interesting. There are different studies. Some suggest it's because they're not getting diagnosed, because they're not getting, probably because they're doing okay, and some suggest it's because they're being counseled out or encouraged not to come in. Same thing goes for expulsion, right? So they are not subject to the same range of regulations. Charter schools now are subject to the same academic accountability rules, but except for in Indiana, they're not subject to the same academic accountability rules for vouchers. A couple of states, Louisiana, Wisconsin, Ohio, make the kids who get vouchers are subject to the same accountability regulations, but not the other kids in the school, which is a truly inane system. In Indiana and Louisiana, if you do badly on the test enough, you get kicked out of the program. I just wrote a paper about this, but it's a big question. And the other thing about private schools is, of course, they have religious liberty exemptions that public schools don't have, including for hiring and firing. So there's a whole bunch of, I think that as private school choice expands, questions about accountable to who and for what become really much more in the forefront. Some of those raise their own religious liberty concerns, and some of them raise, honestly, in my view, kind of stubbornness on the part of the private schools who are like, no, we're not going to take the test, we're not going to report our results. Sometimes the transparency is not bad. I don't know. Anyway, this is a good question. Yeah, Maria Pass.
I was thinking that all those programs related to choice, educational choice, all those have to do with parents' rights. However, there is, at least to my knowledge, maybe I'm wrong, but there is no text that says that parents have certain rights, from a constitutional point of view, at least from the federal point of view.
So,
So what is the foundation for arguing those?
well, these are not, you don't get, this is to your question. I mean, you don't get a voucher because you want one. You get one because the state has decided to create a voucher program. You don't have a right to public funding of your private education. So it's not a parents' rights argument. It's the state creates a program that extends benefits to certain categories of kids. And some kids, it's usually like, it's means tested. It's poor kids, it's disabled kids. Unlike Chile, where everybody could get the voucher, these tend to be limited programs. It's not a parents' rights argument. It's just like the state creates a program and says, like the same example would be like, the state created a program saying that if I changed the windows in my 1919 house to be like, I don't know, more efficient, I would get a tax credit. I didn't have a constitutional right to a tax credit because I changed the windows. They gave me the right by giving me a statute. So it's about discrimination in the programs, not about parents' rights. Now, in every state, there is a right to education in the state constitutions. There has been some litigation, and the Supreme Court has recognized in Pierce versus Society of Sisters and Meyer versus Nebraska that parents have the right to direct the upbringing of their children. It's a due process right. That's never been applied in this context, though. That's just like you have the right to send your kid to private school. You don't have the right to be paid. But there is a right, a parental right. In every state, there is an education right. In no state has that education right been interpreted, the state constitutional education right been interpreted to require parental choice.
I'm not sure if I can ask my second question that I have since I had your course of law of education that I never asked really before.
That was your question?
No, I mean I have a second one that I never asked when I was
Okay.
a student. So I'm not sure if I can ask it. Right?
Sure.
Okay. So I have some questions about the way that the Supreme Court has interpreted the, like secularism, like this is, and I'm thinking also about the public schools, because sometimes religion is forbidden, sometimes religion is part of the cultural thing in America, like when you are going to say the name, like the pledge of allegiance.
What?
Say the pledge of allegiance.
But oh yeah.
There are certain, it's very.
So the Supreme Court has said that public schools must be secular, and there have been challenges. So the content itself cannot be of a public school. If it's a government school, it must be secular. So there are two worlds we're talking about here. The Establishment Clause requires public schools curriculum to be secular, and then the question is, but what else can the government do outside the public system within the confines of the Establishment Clause? So all of these cases that I talked about are about choice. They're about programs, not public school. Not government schools. The charter school thing is, the question in that case really boils down to, are they government schools or not? It's a very complicated question. Now, the Pledge of Allegiance, there are a whole bunch of other cases about kind of how much ceremonial deism is permitted in the public square, and the court has never really passed on it other than to say this is not too much. And there was a challenge to the Pledge of Allegiance a few years ago, but it was punted on standing grounds. But yeah, it's a good question. I mean, starting in the 1940s, the Supreme Court started making clear public schools must be secular. What we call public schools, what you would call government schools.
Yeah, I remember that. So.
Yeah.
So if it were to go your way and they couldn't discriminate among private schools, do you think it could be a deterrent for school choice going forward in these states that don't have school choice for private schools at the moment, because they wouldn't want to include the religious schools?
Yeah, so I think that it is my understanding that if Maine loses, the tuition will probably go away. Of the 31 states that have school choice, only Maine, Vermont, they're the only two that actually discriminate. So I don't think that no state, except those programs are old, no state's enacting a program that's discriminatory anymore. Some state courts have invalidated programs or said the state constitution requires religious schools to be excluded. But yeah, I mean, there's a couple of practical reasons why that is. And one practical reason is you just can't have private school choice without religious schools. You don't bother outside of Maine and Vermont, because if you're a secular provider of education, then you want to be a charter school because you get more money. So there are very, very few secular private schools that are not super elite. Like the gap between a faith-based private schools, like the average tuition is less than $10,000, and if you look at the secular ones, the elite ones are like $30,000. So it's not like you can't say to the poor kids in Cleveland, like, here's $5,000, go to Choate. It's not really going to work out for you. So I don't think that very many programs would go away. Maine and Vermont's might. That's not a lot of kids. I do think also very interesting about the litigation, what's happening. Peter's involved in this defense. We're helping defend the Kentucky program. It's a brand new voucher program. They're not even filing religion claims anymore. They've given up on state religion claims because they're afraid they're going to get smacked down by the federal courts. They're just not even filing them. So, yeah, but you're exactly right. The one solution for the state is to stop subsidizing private education. There's another case that the Religious Liberty Initiative is involved in. It involves a flagpole in front of the Boston City Hall, which has been flying flags forever, and including flags with religious symbols, like the Turkish flag is a Muslim symbol. But in any event, they decided this year to not fly the flag of Camp Constitution because it was a Christian flag. And they're saying that they have the right to not fly this Christian flag. And the Supreme Court just took this case called Shirtlift. It's not an education case, but it is a discrimination case. Like, is it religious discrimination? So look, if Boston loses, I suspect they'll just start flying the Boston flag all day long, not let the neighbors hang their flags. Ironically, the Boston flag says in Latin, "God help us today as you have in years past." But ceremonial deism. I think one more. Yeah.
What's the strategy if your side loses, like, and you have to go back to the drawing board? What do you do?
You know, if our side loses, there'll be fewer lawsuits challenging the exclusion of religious. If Carson makes clear that this is not, if our side wins, two things will happen. People will start challenging charter school laws. That's a big thing. And then I was joking with some of the students in the religious liberty group. There's lots of free religious liberty groups in the United States that have the word liberty in their name. It's like first liberty, liberty and justice. And I was like, one of those liberties. Go see so one of the liberties will start challenging. There'll just be a slew of cases, I think. If our side loses, Maine and Vermont will continue to exclude religious schools from the town tuitioning program. And, I don't think there's a lot of kids affected. And we will continue, not we, but, the advocates for pro-choice will continue to argue in states that the Blaine amendments aren't more restrictive, which is what they've done so far with pretty much success. So I think so there's two last point about free exercise litigation in the United States. Like, there's sort of two paths of free exercise litigation in the United States. Carson versus Makin represents one, which is to fight the exclusion of religious providers or religious entities from the public square and public benefits. That's also this Boston case, Shirtlift, right? It's bad to exclude religious flags. The other one, which is totally different, is about whether or not the First Amendment free exercise clause requires the accommodation of religious believers when the law is neutral. So one is like, let's go fight about all these laws not being neutral. That's what Carson's about. Then there's the other one, which is the Smith line of cases, which is like, okay, the law is neutral, but it's burdening religion, so those are bad laws and unconstitutional too. The court hasn't gone there yet. So that will continue. That line of cases will continue. If Carson is unsuccessful, if there is a status use distinction, then all of this litigation just gets pushed down to state courts. Okay. Well, thank you all for coming.
Thank you again, Professor Garnett. And I'll just put a plug for the Religious Liberty Initiative. There are two classes, transactional and litigation. You can sign up for those in the semester to come, correct? We've gotten to work on cases, as you saw, the briefs went in front of the Supreme Court. I'm involved in another case helping to expand similar kind of issues in a different jurisdiction. It's an amazing experience. And speaking for the Education Law Forum, in this spring, we'll have a panel of speakers speaking to disability access and special education law. So please keep an eye out for that.